webinar titled Post-COVID, the Future of International Arbitration. My name is Alona Bitkivskaya. I'm part of the legal team here at the Singapore International Arbitration Center, and I will be your moderator for today's session. In today's webinar, we're going to look at the COVID-specific changes taking place in Singapore and in Russia, as well as the general recent legal developments in the Russian Federation taking place notwithstanding the pandemic. Namely, the coming into force on the 19th June 2020 of the latest federal law, which will have an effect on the sanctions disputes, as well as the overall impact of the foreign sanctions on international arbitration. And while our speakers will be discussing these changes and these innovations, they will try to critically evaluate which of those will actually stay in the future and which of those will be most significant. And while our panel requires no introduction because they're very well known in their field, both in their domestic jurisdictions as well as overseas, nevertheless, let me take some time to introduce the arbitration specialists who will be sharing their knowledge with us today. So on the Singapore side, we have Edmund Cronenberg and Lawrence Tay. Edmund Cronenberg is the managing partner at the Singapore law firm Bradell Brothers. Edmund's practice areas include, among others, commercial litigation and arbitration, preemptive relief and injunctions. As an arbitration counsel, Edmund represents clients in international arbitrations predominantly under SIAC, ICC, and UNCITRAL rules. Edmund also actively sits as an arbitrator and is admitted to the panels of various arbitral institutions, of course, the SIAC panel, as well as, interestingly, the Institute of Modern Arbitration in Russia. Then we have Lawrence Tay. Lawrence Tay is a senior partner in the dispute resolution practice of Denton Thorndike here in Singapore. He has particular experience in handling commercial disputes, including those of international trade and commodities, maritime and aviation, onshore and offshore construction. Lawrence acts as counsel in arbitration, mediation, and other forms of dispute resolution, and he is appointed regularly as an arbitrator under rules and auspices of various international arbitral institutions, to name just a few: ICC, SIC, HKIC. And of course, Lawrence is also on our SIC panel. Joining our Singapore colleagues, we have the Russian experts. We have Alexey Yadykin with us today, who is the counsel at Freshfield Brookhouse Deringer, based in Moscow. He specializes in arbitration, court proceedings, internal investigations, and luckily for the purposes of our seminar, sanctions. Alexey participated in the development of Russia's new arbitral legislation adopted back in 2015. And the viewers will recall the legislation was an overhaul of the arbitral institutions and the arbitral laws in Russia. Next, we have Dmitry Diakin. He is a partner and the head of arbitration practice in Rybalkin, Gorsuni and Partners, based in Moscow. Dmitry has vast experience representing the government and major state corporations, Russian and foreign companies operating in various industries, including oil and gas, banking, and construction. Dmitry also handles numerous arbitrations under various arbitration rules, including ICC, the Stockholm Chamber of Commerce rules, and UNCITRAL. He is also the deputy head of ICC Russia Arbitration Commission and the member of Presidium of Arbitration Center at the Russian Union of Industrialists and Entrepreneurs. And last but not least, we have Yevgeny Roshevsky with us. He's a partner, co-head of international arbitration and litigation practice at Egorov, Puginsky, Afanasyev and Partners. Yevgeny specializes in management of complex cross-border disputes. His experience in arbitration proceedings under MCAS, ICC, LCIA, the Stockholm Chamber of Commerce rules. He is a member of the SIC Users Council Russia Committee. So having represented the panelists, I would also like to remind the viewers that we have a question-answer function where you could pose your questions to a specific panelist or panel in general. So let's dive into today's discussion. In the first part of our discussion, we're going to be looking at those specific COVID-influenced changes, and arbitration being a very flexible business, which is extremely receptive to the needs of users, it comes as no surprise that arbitration users in various jurisdictions have adopted available technology and tailored arbitral proceedings such as virtual hearings, electronically signed awards, documents-only proceedings, in order to mitigate that disruption, which is happening now across the globe due to COVID. So if I may start with our Singapore experts by asking them, so what changes have arbitration users embraced in Singapore, both tribunals, council, parties, and what are the legal and practical considerations arising from these new practices, especially with regards to the enforcement of awards? Maybe if I may start with Edmund first, and then we're gonna ask Lauren.
Hi, Aliona. Thank you very much for posing that question to me. I'm very happy to be here. I think the main thing we've seen in Singapore is the increased use of virtual hearings, video hearings in arbitration. And while these facilities were available in the past, I think they've become commonplace. It's now more or less the only way we can get international arbitrations where the parties, the tribunal, the witnesses are all in different places around the world, and we can actually get these arbitrations going in Singapore. I think some of the important considerations before jumping into a virtual hearing, even though it's the obvious thing to do, would be to ensure that the lex arbitrae, the law governing the arbitration, actually does allow video hearings. Singapore does. Some other places might be a little sticky about this. Then you check the rules to see if there's anything in the rules that disallows it. So the law shouldn't disallow it, the rules shouldn't disallow it. And then, of course, I think as a matter of prudence, you want the express agreement of the parties as far as possible to the hearing. Understandably, some parties may not be so keen to get going with the virtual hearing because they might be on the respondent side and seeking to delay. So, I mean, that could be an impediment. If the rules allow it, the law allows it, then tribunals would probably want to get on with it. That's in terms of the law, but in terms of technology as well, I think some of the things that we've seen happen are people upping their game in terms of the technological capability of running virtual arbitrations. We know Maxwell Chambers, for example, has a wonderful setup there, and I'll leave Lawrence to tell you more about it because I think he's got a case going on there. But you know, a lot of us are doing hearings from home. Because we've been working from home. So it's a question of, as counsel, making sure that you have the technology that supports it, big enough screens, good enough cameras, and also, and a lot of people don't think about this, ensuring that the tribunal has that technology as well, because you may have the best setup as counsel, and then the tribunal is operating off of an iPad, or worse still, a mobile phone, a very small screen to work with, and he can't see anything, let alone the demeanor of the witnesses, let alone the documents that you are sharing on screen. So it's a very important thing to apart from considering your own technological ability, to consider what the tribunal has, each and every one of them, to ensure that they can see you, hear you, and see your documents and see your witnesses.
Absolutely, thank you, Edmund. And I think if I'm hearing a piece of advice coming very clearly from you, is that please do check with your tribunals that they're comfortable with the way you intend to proceed with the remote hearing. Because at the end of the day, if you know, they're the ones who will be deciding your case. So if I then may ask Lawrence to contribute as well, and maybe share with us some personal war stories or personal anecdotes he has in relation to work during COVID times.
Sure, thank you. I'd like to pick up from a point Edmund made, which is that you need to look at the seat or the place of the arbitration and ask yourself whether virtual hearings in all the different forms that we now can imagine is actually allowed. I think that's a very important consideration that will be the first consideration, because if new procedures, new media are not allowed, or if there's going to be an issue, these things have to be noted and ironed out before we can think about how to adapt processes to meet the COVID environment. I'll come back to that a little bit later in terms of the law on arbitration, which I think would be important from a tribunal's perspective. But what I would like to say is the challenges that COVID presents really aren't that new. There've always been challenges to processes and hearings caused by one thing or another. Today, of course, it is because of a pandemic, but tomorrow it could be simple things like travel restrictions. And that existed even before COVID. So and as I said to the other panelists in an email yesterday, the great thing about international arbitration is the flexibility of its procedures, and it's best suited among all the modes of dispute resolution to adapt itself to meet the circumstances or the problems that present. One more story I can talk about happened many years ago before we even reached the level of technology that we now have. And it was a very high stakes arbitration hearing. I was counsel for one side. And as counsel, you would prepare and imagine the cross-examination that will take place of the other side's witnesses. You want to get certain answers, you want to make certain points. And I had imagined a conventional hearing where everyone was going to be in a room, only to be told at the last minute that the witness, the star witness for the opposite side, was not able to travel to Singapore. I won't go into the reasons why precisely he wasn't. That's a separate matter in itself. So that's surprise number one. And surprise number two, I was also told at the last minute that star witness was not able to give his evidence in English and was going to give his evidence through an interpreter or translator. Now, that coming at the very last moment makes you have to revisit, revise, and rethink your whole plan to cross-examine a witness. You have to take into account the lag time. In those days, we didn't have the kind of high-speed connectivity that we have today. You have to make allowance for gaps in interpretation or translation. It wouldn't be the kind of cut and thrust that you would have questioning a witness in the same room. One of the things to take away from this is that a tribunal also needs to be aware of some of the difficulties that technology can present. And my arbitrator was quite astute. She, yes, it was a female arbitrator. She had the presence of mind to use two forms of media, one as a backup and one as the main one. The hearing took place in Maxwell Chambers. Lo and behold, the higher technology main media kept failing all the time. Now, I have my own suspicions as to why it kept failing. It might have something to do with the country with which we were connecting and perhaps their ways and means of allowing connectivity. But the backup was good old Skype, and we did most of our hearing on Skype because the main media platform kept failing. But had it not been for the arbitrator's presence of mind, the hearing might well have to be abandoned, at least for that day, and then reconvene, causing a lot of time and energy wastage. Now, I promise to come back to the tribunal's perspective, and I'll make my points very quick. I always think that international arbitration, from the tribunal's perspective, despite all the flexibility, the tribunal needs to bear 2 or 3 things in mind, which are absolutely, at least in my view, incapable of any compromise. One is the tribunal must always ensure equal treatment of the parties. And the second is that they must be given a full opportunity to be heard. Once these things are ensured, because the Untitled Model Law guarantees them, then any amount of flexibility within reason is allowed. As I've said, arbitration is flexible enough. As long as you have these 2 things in mind, you won't go far wrong in the conduct of arbitral proceedings. Thank you.
So summarizing what you are telling our audience, so it's not that we have all of these innovations suddenly coming in the times of COVID. It's we have the old good procedures which we started to use more often and on a wider scale, right? And if I may pick up on the point which you raised in relation to the equal treatment and the party's opportunity or right to be heard, would you agree that certain parties may be making an argument that, like, if we have an uneven access to technology, right? Or if we have certain technological difficulties related to participating in the procedure, that somehow it breaches the equality of parties. Would you see such an argument being made?
Yes, and again, I choose to answer it from two different perspectives. One from the perspective of counsel receiving that challenge, and one from the perspective of the tribunal. Of course, as counsel for the other side, it is natural to be skeptical about these points being made and wonder whether they are strategic or even tactical points to gain some sort of advantage or as part of a wider plan, and you would raise the kind of objections that you think fit. From the tribunal's perspective, I think this is something that the tribunal has to listen to, and the tribunal should satisfy itself whether there is indeed an uneven playing field in terms of opportunity or in terms of equal treatment. Because at the end of the day, most, if not all, tribunals want to make sure that they issue an enforceable award.
Aliona, if I could just jump in on that, I think I fully agree with Lawrence, but on practical, in practical terms, the optics of the situation have to be really carefully managed by the tribunal. So you shouldn't have, for example, as far as possible, in my view, a situation where one party is physically present with the tribunal in the hearing center and another party is dialing in from somewhere else. Even though that may be perfectly fair, the optics of it may be a little bit problematic. And so even if one party is in the same place, in the same location as the tribunal, I would say, sitting as the arbitrator, both parties should be dialing in. Nobody should be in the same room as the tribunal. And then it's a question of lowest common denominator. What kind of technology can you all agree on to ensure the accessibility of that technology to both sides and the tribunal, as opposed to going for something that's really super high tech? That puts that for example puts a huge drain on technically on your resources, and there are some platforms that, because of the resolution, because of the amount of data being transferred, puts a huge drain on resources. This goes to Lawrence's point about the more high-tech solution causing problems. That you might just want to say, let's go for the low-hanging fruit, the lowest common denominator. Let's go with that, and it might be Skype, it might be Zoom. It might be something like this, so that it becomes more accessible to both sides, thereby decreasing the risk that one side will say, I'm prejudiced because I can't make that technology work for me.
Absolutely. Thank you, Edmund and Lawrence. I guess it's perfect advice for our users. Well, then maybe if I may move to Dmitry. So Dmitry, what is the situation in Russia? Do you see similar trends happening in the Russian jurisdiction in relation to tailored procedures? Virtual hearings, for instance, and how does that affect the enforcement considerations?
Yeah, thank you, Elena. I want to discuss a bit of statistics which I gathered from the Russian arbitration institutions. But before that, I would like to make several observations which might be helpful for the audience. I saw the list of participants and noted that majority of the participants are not from from this part of the regions, which I'm a bit surprised to, and see a lot of Singaporean Asian participants. Many of them are my friends, so just a bit of a couple of observations beforehand. First, I want to state that definitely the Russian arbitration community sees the rise of the hearings conducted through video conferences during the pandemic, especially during the pandemic. This is already the reality. Second, I would like to touch a bit of legal basis for this. Indeed, the federal law on arbitration, arbitral proceedings in the Russian Federation provides the opportunity for the parties and the tribunal to conduct their hearings in the virtual form, especially Article 27 point 4 gives this opportunity when parties to the case agree to this. Third, I want to remind the participants that there are several arbitration institutions in Russia which were granted a license to administer the arbitration. But I want to stop only on 3 of them, which probably the largest and most significant ones in the arbitration reality in Russia right now. First is ICAC, International Commercial Arbitration Center. Second, Arbitration Center at Russian Union of Industries and Entrepreneurs, where I'm affiliated to. And third, Russian Arbitration Center at the Institute of Modern Arbitration. All of them quite prestigious, important, with ICAC being the traditional, which exists for many, many years, over 75 or 80 years, taking the history from the Soviets, the start of the Soviet Union. So, and I want to discuss a bit of how the arbitration rules play around the possibility to conduct virtual hearings. ICAC took the very conservative approach. The rules don't contain the special provisions for conducting arbitral proceedings in virtual form, but they contain the provisions where the cross-examination can be conducted through the video conference. So that means that, you know, the virtual hearing might be only if the parties agree to this. The different approach was taken by 2 Romanian institutions. Both institutions of Russian Arbitral Center of Russian Industries and Entrepreneurs and Modern Institute took the approach where the tribunal can grant the virtual hearing form upon the application of one of the parties. So that means that there is a discretion of the tribunal, and this quite useful and comfortable. So, and now I'm moving to the statistics itself. You know, I gathered some statistics. Some of them is public, some is not. But it would be interesting for the Singaporean participants, given that I understand the SIAC just released the new recent statistics showing the rise of tremendous rise of number of cases. So what is happening in Russia? In ICAC, 2017. 363 cases, 2018, 454, 2019, 522. So it's definitely a rise of a number of cases. The Russian Union of Industries and Entrepreneurs, 157 in 17, 240 in 18, and 305 last year. Again, it's almost doubling the number of cases during the last 3 years. Russian Arbitration Center actually gives more or less the same statistics. So last year it was 253 cases. It's interesting also that there is, there is a change inside the caseload of institutions, partly because of 2 things. First, that the number of arbitral institutions decreased as a result of the arbitration reform from the unknown number of institutions, because nobody really counted them. It's probably more than 300 existed before the reform, and now it's not so many. And many of the regional disputes came to them, to these existing institutions. And also the number of real international cases. I understand that ICAC the caseload of ICAC, of international case in ICAC decreased, a number of internal cases increased, and that's a bit of interesting fact, suggesting that ICAC losing a bit of market share of international dispute, but probably in favor of international centers, or in favor of two remaining other centers. This fact shall be explored and proved by firm statistics, which I don't really have at the moment. And the last point, what is happening with the virtual hearings? Yeah, probably that was the question of the major question of first part. So it's interesting. Honestly, I don't have the statistics in ICAC, but I had an informal discussion with the head of administration, who told me that yes, it's increasing, but it's not tracked by firm statistics, and approximately 10–12% of all hearings conducted in the form, not in the physical form. That means both virtual hearings and, which I believe happening more often, in the form of exchange of documents, so without physical presence at all. So this is approximately 15% of all case law during the pandemic. A Russian Arbitration Center showed the firm statistic among 41 cases which were conducted last quarter, more than 20% were conducted in the form of virtual hearings. And the Russian Arbitration Center at Russian Union of Industrial Entrepreneurs, here I have more firm statistic and proven the number of virtual hearings growing very, very much over the last 4 years. If in 2017 there were only 2 hearings in the virtual form, in 2018 17 hearings, in 2019 already 54. During the pandemic, there were more than 40 hearings. During the last 3 months, more than 40 hearings in the form of virtual hearing. So this center uses quite often the technological form of conducting the hearing, so which is a good sign for the Russian Arbitration Society.
I see. So we can safely say that, well, Russian arbitration users are also adapting and are also going virtual. Maybe not at the same speed that Singaporeans are, because we are almost virtually virtual at this point, but well, catching up. And very interestingly, just to bring back the point which you, Dmitry, spoke about in terms of certain arbitral institutional rules providing for certain procedures when we come to consider the virtual hearing, right? And it resonates with the point that Lawrence and Edmund made, that first of all, one should ensure that if you are going with the remote hearing, not only the law under which you are arbitrating does not prohibit that, but also the arbitral rules of the institution which you have chosen do not create obstacles, and you actually abide by the procedure. So thank you for that. And then maybe just to give some wide overview, because with COVID, we do understand that it's an immense strain on the global economy. And while we adapt and while the users come up with new ways to move forward with arbitrations, there's also a lot of negative impact on business. So maybe if Evgeny, you could firstly comment with your observations on what is happening in Russia, if you have any, and then maybe if you could give us an overview. So, you know, if you look into the future, are there any prospects? Because everything seems to be a little bit dim at this point. So which would be the areas of growth which could benefit Russia-Singapore arbitral cooperation in the future?
Thank you very much, Aliona. Good afternoon, colleagues. Thank you very much for the opportunity to speak today. First of all, to your first question, Aliona, about what's going on in Russia and what opportunities it could bring to arbitration. Of course, I can speak only from Moscow perspective primarily because we were all isolated until at least early May, not allowed to travel broadly. But around our area of practice, the most hot topic would be renegotiation of the lease terms. And interestingly, this could have been because Moscow is the major place for the rental business of offices premises, business of big trade centers which lease premises to smaller shops, businesses. This could have been a lucrative area for development of the arbitration practice and even before arbitration mediation practice, because normally what has happened was that both sides screamed, both tenants and landlords, that both of them are most important for the economy. And none of them can be treated more badly than the other side. And there should be a special law passed to defend them and so on. And actually, Russian legislators, like legislators in many countries, adopted several stages of emergency packages of legislation and statutory instruments governing this situation, including early termination of lease agreements without sanctions. But again, as I said, I would rather see these kind of situations resolved through expedited mediation, for instance, which would have been cheap, because our firm, for instance, like other firms, were approached to assist in negotiations, but not just as a representative, but rather than a mediator, depending on whom you represent, landlord or tenant, to persuade, to take into account the changed emergency circumstances, force majeure, and so on. And for instance, to have the rental holidays for 1 quarter or reconsideration of the hard currency rents to ruble rents, and so on. And I think there was a problem, at least in early stages, there was a problem of flexibility. Parties just didn't know what instruments they could employ. There were many webinars, and law firms prospered on giving various alerts. But the truth is that business needs somebody to resolve the disputes expeditiously. And of course, without, in this vacuum of arbitration or mediation clauses, and I stress this should be expedited dispute resolution, not 6 months, 12 months. We should look for 1 month to I don't know, maybe 15 days. These disputes went to courts, and there is a court practice which slowly is built up. The luxury of Russia is that litigation, commercial litigation, is cheap. We have the capped amount of court fees, and even if you lose, you may end up paying a fraction of the costs of the lawyers of the other party, but not the real market terms. It's a big problem, but on the other side, this continues to keep arbitration business disputes in the domain of state courts. Looking into the future, I have to stress that global Russian projects, infrastructural projects, are going on, and there is a state goal to continue them to be implemented, like Arctic region development projects or big construction of the roads or railroads. And of course, this is all done with attraction of the foreign investments, opportunities for joint ventures, starting from the biggest, like Yamal LNG, and going to medium size. Part of it is a state procurement, which is difficult to arbitrate in Russia, because it's a kind of hot topic issue area. What arbitrability you may have on state procurement, but this is a development area of law. However, definitely there are opportunities in joint ventures, arbitration clauses. There are opportunities in supply of resources such as hydrocarbons, metals, from east to the west. And this east to west supplies are currently primarily in the European arbitration institutions. First of all, we keep in mind Stockholm, which is the preferred venue for Russian gas disputes, which we could have seen recently, and the applicability of the Swedish material law. Now I think it's changing because of some unexpected results to the suppliers from recent arbitral awards, when consumer protection regulations were applied by the tribunal to business transactions. This gives opportunity to Singapore law because currently the vacuum is filled up by English law, and it's a well choice for traders, but there should be bigger choice. Unfortunately, I like this citation, which I read recently. The law became quite provincial. Every law firm, every specialist just persuades for his type of regulation, local regulation. We forgot about wide application of lex mercatoria, unidroit principles. However, they are still there, and this can save contractual relationships in this difficult environment when local laws can be very harsh, or they can be connected to sanctions, for instance. What Russian parties face is, and it's a quite big challenge for lawyers to answer to, would a sanction regime, which is adopted by some country, be part of the material law applicable to the contract? In Gazprom arbitrations, it was not, unfortunately, somehow connected to sanctions, but there was an issue of public laws applicable to Swedish law as part of the EU, because Naftogaz argued that EU antitrust laws should be part of the Swedish law chosen by the parties. Arbitrators refused this argument. They discharged it. They said that EU law is a distinct part. However, the question remains because Sweden is part of EU. And if you pick up Swedish law without any special carve-outs that except of the mandatory union law, so on, it's still a question. So this needs to be kept in mind. I know that Singapore has a very sophisticated legal system. Big opportunity is transparency, presence of renowned international judges, specialists, well-developed legal profession, because these disputes should go somewhere. I mean, East-West disputes for transportation of hydrocarbons or resources or joint venture, they should go somewhere, and Singapore is accessible. What I think should be looked further is presentation of the panels of Asian, Eastern arbitrators to Russian business and consumers of arbitration services, because we well know European arbitrators. We don't have any problem of selecting arbitrator if we have proceedings in London or in Stockholm or Paris. However, if you speak about Singapore or Kuala Lumpur, you need to consult local best friends. It's not so easy. Still, the distance matters in this situation. So there's a big, I think, opportunity which is lying ahead here also.
Oh, thank you, Evgeny, firstly for the good news that there are areas for us to work in, and also for the advice that, well, Asian arbitrators should make themselves better known for the Russian businesses, which I think would help in the future. And you also touched up on the sanctions point. So that gives us a very nice transition into the second part of our today's discussion. So basically on the, well, somewhat maybe controversial federal law, which is known more widely as Lugovoy Law after its author. And as we know, well, it comes into force on the 19th of June 2020. And I would like for our panelists to actually look exactly as to what is entailed within that law and how does that affect the arbitration disputes concerning the Russian parties. And if I may ask Alexei to start off, maybe to give us the overview, to discuss the lagunas in the law, if any, and just generally your views of the sanction regime.
So thank you very much. In brief, this new law, it pronounces that, well, without going into technicalities, basically what it does, it pronounces that disputes involving sanctioned entities, and I'll just explain in a minute what this means, what they are. Those disputes are within exclusive jurisdiction of Russian courts. It applies to mostly, of course, and primarily it applies to Russian entities which get targeted by foreign anti-Russian sanctions. Of course, it also applies to their foreign subsidiaries, which especially this, and this is how it works in practice, because very often Russian business is structured, especially big business is structured internationally. Very often there is either an offshore holding company ultimately under some Russian oligarch, or there are offshore subsidiaries of a Russian entity. There might be a multitude of variations, but basically if a Russian national or a Russian company gets designated, it well may be that its foreign affiliates and subsidiaries are also designated and affected by sanctions. So this is the first group which is targeted. And the second group is actually could be foreign parties, non-Russian parties, any parties which are captured by the so-called secondary sanctions, which is, for example, if the US sanctions, I don't know, some European party for dealing with the Nord Stream pipeline, or with some Crimea matters, or for having some significant dealings with Russian SDNs. So it's potentially quite a group of people. So the fact that this law brings the disputes involving those people, those companies, into exclusive jurisdiction of Russian courts, well, it sounds scary. It is scary, but in reality, the law recognizes that those entities may have entered into prorogation, choice of court agreements, or arbitration agreements, and I'll now focus only on the arbitration side, because that's what typically happens in international business. There would very often be a dispute resolution clause which refers disputes of this entity to arbitration outside of Russia. So the good news is that the arbitration clauses of those sanctioned entities, they are not killed immediately. They don't become unenforceable, invalid, whatever. But the law creates an opportunity for the sanctioned entity to go to a Russian court and basically do two bad things. Well, bad from the viewpoint of the foreign counterparty. One thing is to have the dispute adjudicated on merits in Russia, despite the existence of the arbitration clause. And the second is to get a Russian anti-suit order, which is quite interesting and novel, because we've had this discussion about whether it's at all possible from the Russian procedural standpoint, from the Russian law standpoint, to have a Russian court enjoin somebody from legal proceedings. There was a lot of talk whether this was constitutional, possible, legal, and I'm not going into the history of this, but the short takeaway is that now this is made possible by the law. Interestingly, it's drafted as in such a way that it's not an injunction which can be obtained momentarily, but it looks like it should be proceedings as if those were proceedings on merits, which means that parties must be summoned, there must be some time, and sometimes significant time spent on due service on a foreign party. But anyway, once this is done, it's possible that the Russian court will issue an order which prohibits the foreign proceedings. And in the event that, in the likely event, I would say, that the foreign party and the tribunal abroad just disregards this order, and either a foreign party starts proceedings in some foreign institution against the Russian party, in violation of this Russian court order, or the foreign party has done so before the order and continues with the arbitration despite the order, then the Russian court can impose a fine. They can order the foreign party to pay up to the entire amount which the foreign party claimed or is continuing to claim in the foreign proceedings, plus legal costs. Then, of course, there is a separate issue how and in which circumstances this Russian reward might be enforceable. But of course, this depends on whether the foreign party is exposed to Russia, whether it has a subsidiary in Russia, some assets in Russia, which can be easily targeted, or if it's insulated from Russia, it has assets somewhere. In theory, I could imagine the Russian party trying to enforce this order even outside the Russian borders. But the big and the big uncertainty about this law is that all of those options, going to Russian court for adjudication on merits or going for the anti-suit injunction, those are only available to the Russian party, where it can demonstrate to the Russian court, where they have an arbitration agreement, that the arbitration agreement is no longer capable of being performed. Basically, it has become non-workable, or at least the Russian party can no longer participate in those foreign proceedings, or in the terminology of this law, there have been impediments in the access to justice for this Russian party as a result of foreign sanctions. And then the big problem here, or big uncertainty here, is that how do you measure that? How do you establish that? Because the law doesn't say, for example, what level of sanctions would be sufficient to establish that indeed for example, your LCIA arbitration clause has died, that it can no longer be performed, or at least the Russian party can no longer participate. That's all open to debate. And in reality, as we know from Freshfield's practice, yes, of course, it could be that foreign sanctions could have a serious impact on arbitrations. That's true. But first of all, it really depends very much on what type of sanctions applies. Because if those are sectoral sanctions, for example, those which now apply to many Russian state banks, yes, it has some limitations. It impacts their ability to get cheap credits in the West. Yes, it also has to be considered by the institutions, and European institutions, they now have those questionnaires at the start of the proceedings to identify if a party is subject to some sanctions, for example, sectoral sanctions. But in reality, it has no impact at all on the arbitration. It proceeds. And a very different story is, for example, a story which we had to deal with is where one of the parties becomes an SDN. But even then, of course, if a party becomes an SDN, serious problems will arise, especially if they are also targeted by mirror European sanctions, right? So if they are blocked under EU laws and US laws, yes, you would probably be unable to pay deposits, for example, in dollars or euros. You may have problems with experts, arbitrators, even parties from those regions, from the US, for example, US persons participating somehow in those proceedings without getting the license. But again, does it mean that the arbitration clause has become incapable of being performed? For example, even if a Russian party has become an SDN, and there is, for example, the proceedings are happening before an institution in the US or in the EU, which may need to get a license from the local sanctions regulator. Is it the end of the story? Is it the end of it? Not really. In reality, it's possible to get a license, and those proceedings can and do proceed. Yes, there is a serious impediment. Yes, time may be lost, and be sure that your opposing party, or maybe it would be you, who would create a lot of noise and a lot of problems, and make a lot of arguments about the impact of sanctions. But in reality, as a matter of practice, those arbitrations may well continue, then we go back to this new law. So it doesn't really say how to measure. So, for example, if the sanctions made the arbitration conclusively and finally impossible, that might be one situation. But another situation well may be that subject to filing for a license and subject to some waiting period, it could be possible to resume this arbitration. Or it may even be that the impact of sanctions is even lower, and maybe you don't, especially if your arbitration is in Singapore or Hong Kong, which have no anti-Russian sanctions. There still may be situations where they would be exposed to US and EU sanctions if you have, for example, parties from those regions, but the impact would be lower. It might be that you could even continue without major impediment in those arbitrations. So how do you define this in Russian courts? Which of those situations triggers this new law? Unfortunately, there is no answer to this in the new law. And there was, to my knowledge, there was at least one case before the new law which dealt with this situation where a Russian party had an ICC arbitration clause, and they became designated as an SDN. They came to a Russian commercial court and argued that the court must take this case and hear it on merits in Russia, because the arbitration clause has become incapable of being performed, because we are now an SDN. We cannot, there was a lot of arguments, but basically they were all boiled down to the point that designation as an SDN makes the arbitration impossible for this Russian party. I'm not sure it's true, but that was the argument that was made, and that was accepted by a Russian court. And yes, it's possible that in future, now this has been codified in this new law. It is possible, yes, there is a risk that in similar situations, Russian courts might also find that this new law is triggered. So that's, I think, the basics about this new law. Unfortunately, yes, there are uncertainties in it, and parties just have to bear them in mind and see if there is a workaround as a practical matter when negotiating your arbitration clause.
Well, Alexei, thank you for this excellent overview of the new law, but more importantly of what the law doesn't say, or where the risky areas are. And if I may ask then Dimitri to continue with our discussion, maybe you could walk us more from the anti-suit injunctions, which naturally would become quite a norm with this new law. And if you could share with us your views on the federal law and on the risks that it poses.
Yeah, sorry for that. Yeah, I think Alexei just covered the anti-suit section. But I want to reiterate three things from the practical and academic perspective. First, anti-suit injunction is indeed novel for the Russian procedural doctrine. It's never existed in the Russian doctrine at all. And it's something which we need to digest, think over, and accept. Second, it's indeed the injunction which is supposed to be made not ex parte. So, which means it is quite a strange provision in my view, and I think it would be developed further. Just think of the theoretical, or probably practical situation where the court should summon the parties in order to consider this issue of anti-suit injunctions, in order to issue anti-suit injunctions. Given that the foreign parties should be served and notified properly, and it would take normally half a year or so, or even more, and then the effect of anti-suit injunctions might be decreased significantly by this fact. And third, and I think that the legislator would go further, given the right to the courts doing it ex parte, in my view, because inter-party would not make sense in the long run. And third, as Alex said, that the fine for non-compliance with anti-suit injunction order quite significant. It used to be very small in Russian practice. It might be equal to the amount of the dispute, which might be again quite big. I saw the question from the participants, which was addressed to Alex, but I can answer here that the fine for non-compliance only imposed on the parties which ordered to refrain from foreign litigations and arbitrations. One more observation on practical implication of Lugovoy Law. It's indeed quite interesting, and the arbitration arbitration agreement must be trumped by this law if it becomes inoperable. And Alex correctly outlined the cases where it's possible. But it's also gives the possibility to think of unequal treatment of the sanctioned parties, which might be in a different procedural position. For example, if the sanctioned party is a claimant, and here the obstacle is to pay the arbitration registration fees through the European bank, which has the correspondent bank of, normally JP Morgan or another US bank, and that becomes a problem. And you can say that, listen, yes, I cannot pay, I'm not able to pay, and then it's inoperable. But if you're a respondent, then the claimant can take the part of your arbitration fee, which should be paid to the institution, and then that's fine. And you cannot refer that the arbitration agreement is not operable, because it's definitely it might create some other obstacles, but not with regard to the payment. It's something which we need to digest and actually test through the court practice. That's practical observation.
Very interestingly, thank you. And I think it gives a better understanding of how this may play out. And Evgeny, do you have any comments on the law before I ask our Singapore practitioners to give the the look from the overseas on what's happening in Russia? Evgeny?
Thank you, Alena. I would join to the previous comments that nobody knows how it's going to be implied. And second, I think that community generally is puzzled because we are operating in global environment, and I was speaking today about various opportunities which are emerging cross-border on various transnational projects. However, this law is a local remedy, and it is just the remedy which is needed, may be needed in our modern times when Russian businessmen do not have access to justice. Some of them may not have access to justice, access to arbitration, like some of our clients. When access is delayed for 6-9 months, arbitration cannot start and nobody can help. And arbitration institutions are applying for licenses and no answer comes. But we, as international practitioners, we have to take in mind how these rulings of Russian courts will be treated and considered abroad, of course. And this fragile mutual respect of different legal systems should not be undermined.
Thank you very much. And then if I may ask Lawrence, what would be your views on the sanctions regime? What would be your views on the federal law? How will it impact the disputes we have? And any other observations you may have as to the comments made by the Russian practitioners?
Yes, I found what our Russian panelists were saying very interesting. And of course, I've read up on the Lugovoy Law, and I've had regular discussions of it with my partners in St. Petersburg and Moscow as well. I think some of the interesting issues that arise, and I have three in mind. One at a philosophical level is that an anti-suit injunction, in my understanding, is more a creature of the common law tradition. It's certainly not, it's frowned upon by the EU. And I recall the case of West Tankers in particular, where the European court regarded an anti-suit injunction to be basically an incursion into another country's court, even though the English concept of an anti-suit injunction is a prohibition, or as Alexei says, enjoining the party itself. So I found that interesting that Russian law should have this concept of an anti-suit injunction. For me, and again, this is what I have to discuss regularly in arbitration matters that are developing out of Russia. The interesting concept is this thing about an arbitration agreement being unworkable, or there being an inability to access justice. The question that I often have to consider with my colleagues in Russia would be, is it closer to the international arbitration concept of an arbitration agreement being void, inoperable, or incapable of being performed? Is it closer to a situation where a party can demonstrate that it cannot get equal treatment or a full opportunity to be heard? Or does it extend to situations where carrying on with the arbitration is seriously inconvenient? Travel, remittance of funds, for example, do they give rise to the exclusive jurisdiction of the Russian commercial courts? Needless to say, I defer to all of my Russian colleagues on the panel for the answer. I can't pretend to be an authority, but I think those are the interesting questions that arise, which really goes on to the third point I want to make. We've heard about the possibility that the Russian sanctioned party can apply to the Russian commercial courts for an anti-suit injunction. Don't forget, we can have a situation where the non-sanctioned party, upon hearing that the Russian sanctioned party is seeking to access the exclusive jurisdiction of the Russian commercial courts, runs to the arbitral tribunal and says, I want you to issue an anti-suit injunction to prevent the Russian sanctioned party from starting Russian commercial court proceedings, or indeed to prevent him from applying for an anti-suit injunction from the Russian commercial courts. Arbitral institutions have been known to issue anti-suit injunctions. Of course, there is more than one school of thought if you research anti-suit injunctions issued by arbitral tribunals. One is more bullish, one is more conservative, but the power to issue anti-suit injunctions does exist under Singapore international arbitration law. And that, for me, is another area that'll be interesting. All of us might one day act for a Russian sanctioned party. All of us might one day act for a non-Russian sanctioned party, where the other side is a Russian sanctioned party. So we need to be aware of these angles so as to best serve our clients. Thanks.
Yeah, thank you, Lawrence. So before I ask our Russian panelists to maybe comment on Lawrence's remarks or answer the questions he raised, can I also get Edmund's views? But Edmund, may I also ask you to actually let us know where Singapore stands in relation to the disputes concerning the sanctioned entities? And then the secondly, maybe given the overview of the federal law, could you make an argument for the parties still going for arbitration, notwithstanding the new federal law?
Yes, thank you, Aliona. My understanding, okay, I'm not a ministry for law, so this is not the official government position, but my understanding is that notwithstanding the sanctions, for example, SIAC arbitrations can continue in Singapore. It's not so much a function of Singapore, but it's a function of, I think, the institutions and whether the institutions will accept, let's say, deposits made by parties towards the arbitration. This is, to my belief, one of the major impediments that some sanctioned parties are having, where they have arbitrations, say, seated in Paris or in London, they're not even able to get the arbitrations off the ground because they can't get the funds in. As I understand it, Singapore doesn't have that problem. You can put funds into Singapore, you can start a SIAC arbitration, and even if there's an issue, SIAC, I believe, has a very, very close relationship with the powers that be and can explain that this is for the purposes of an arbitration. It's not some normal commercial transaction, and things can go on in Singapore. So on that score, a practical way of resolving the solution, from my perspective, might be for the parties to actually get together and say, look, we've got a problem with this arbitration in Paris or in London. You know, because of the Lugovoy Law, we've roughly got two broad alternatives. One, we go to the Russian courts per the law, because we can't get the thing going in certain jurisdictions. Alternatively, because you and I both wanted arbitration to begin with for reasons of our own and not the courts, shall we select a different seat for the arbitration and perhaps a different institution to administer the arbitration? There could be a question of registration here, whether that institution is allowed to run certain kinds of arbitration. But leaving that aside, let's select a different seat where we can actually get the funds into that particular country without any of the issues surrounding the sanctions. For that reason, you know, parties having selected arbitration obviously did so for a reason. And part of that could be the confidentiality. Part of it could be the fact that they don't want to go to the state courts in their particular jurisdiction. So I don't think parties are going to be running, please tell me if I'm wrong, my friends from Russia, but I don't think people are going to be running to the Russian courts just because of this. I think even before that, they're going to be thinking about, can we have the arbitration in some other place with some other institution so that we can have our arbitration as we agreed. Thank you.
Thank you, Edmund. So if I may call on our Russian experts, so maybe to start with Yevgeny, any observations on the points made by the Singapore colleagues?
Yeah, thank you, Elena. Thank you, Edmund. I think Edmund made a very valid point that Russian law does not put incentive on the parties to run to Russian courts. Actually, if parties want to continue to arbitration, they can do that. And if they do that, they revoke their right to go to Russian court. They just waive it. They don't have to go to arbitration if they want to go to Russian court, and they must prove that they cannot. However, my experience shows that if you want to access the best pool of arbitrators, I don't know, top 50 arbitrators nowadays, and we are all getting involved in major disputes routinely. Russian companies get involved in major disputes where you want to have a high caliber arbitrator. High caliber arbitrators are very cautious. They want to make sure that they don't get under the risk of secondary sanctions. And since there is no global license of OFAC for any arbitration in any part of the world under the auspices of the New York Convention to be excluded from sanction regime, you never know. And arbitration gets dragged, actually, which kills it, because there is no timeline for answering to the request for a specific license, which are granted, but it may take unpredictable time.
Alexei, would you be able to make your observations on the Singapore colleagues' comments?
Yes, thank you. First of all, I would totally agree with Edmund. I think in my experience and in our firm's experience, most Russian big businesses which agree to, for example, to Singapore arbitrations, they are quite sophisticated. They would normally actually prefer to have their dispute resolved in a foreign arbitral center, especially for those bigger projects. And for them, actually, this new law, it's they would definitely, most of them would view this new law actually as a problem and not as an opportunity, because it creates some suspicion on the foreign counterparty side. It creates some obstacles or difficult new issues in negotiating arbitration clauses. And as a matter of reality, most of the big Russian businesses, they are quite sophisticated international, they would, well, just doing this trick and running for the Russian court and then trying to hide inside Russia, hoping that if there will be a foreign award, then it will not be enforced. It could happen with some parties, and maybe the law was designed to protect some of those parties. But for most Russian parties, there is it's the last thing that they would really do. So it's very important for our foreign friends not to be too alarmist about this new law, because yes, it creates an exposure, there is no denying, but as a practical matter, for most cases, the downside of going this way are too big for the Russian party to even try. So that's, I think, one comment. So basically, it's not that some disaster just happened, and your arbitration clauses are just dead, and the Russian parties will now try to trick you. Not really. So that's point one. Point two, I also second the point that it will maybe that there is a fight of anti-suits. So there is a if in the scenario where a Russian party seeks it, it will maybe that a Russian court would enjoin foreign proceedings, or more specifically enjoin foreign parties from continuing with those proceedings, and the foreign party will disregard it, or it will, and the arbitrators may disregard it, or they may even go for an tribunal's anti-suit, which will contradict the Russian anti-suit. As a matter of reality, it will maybe that the arbitration will continue and there will be an award on merits against the Russian party. And then ultimately, it's a question of where do you enforce, and whether the Russian party is really insulated in such a way that there is absolutely no exposure for it outside of Russia. And frankly, at least big Russian businesses are not like this. Nobody can really be in this position that they have no exposure outside of Russia, or they do have this exposure, and then it will may be just impractical for them to use this law because they're exposed outside, and their vote may be enforced somewhere else. In addition, of course, it will be a serious reputational damage for them among the foreign counterparties if they do so. So, as a matter of reality, they may just continue, even without a foreign anti-suit. It will just continue with this arbitration if they can, if the sanctions really don't have this blocking effect. And yes, by doing this, they will simply waive this law, and their vote will be enforceable against them in Russia. And just finally, a very good point was made, how we should interpret these provisions in this new law. So basically, is it triggered only where the arbitration clause has become incapable of being performed in the traditional, in a New York Convention, basically meaning, or whether some lower degree of interference, some inconvenience to the arbitration also counts. Basically, nobody knows. I think logically, it should be the former, but it could also be the latter, because the law now uses this more broader term of obstacles in access to justice. And again, it's really untested for now. Nobody knows how to interpret this. And being on the cautious side, you would probably think that at least it's possible that somebody will argue that even an inconvenience created to an arbitration would qualify for this figure. But there would be, of course, quite strong counter-arguments too.
Thank you, Alexei, especially for this positive note that this federal law is not the end of the cross-border disputes involving sanctioned entities, cross-border arbitration disputes. So thank you for that. And to conclude our webinar, may I ask for Dmitri's comments, and maybe Dmitri, you could also give like a one piece advice to our arbitration users when they do proceed with their arbitrations involving sanctioned entities and triggering the federal law?
Yeah, thank you, Alena. First, I'd like to agree with both Alex and Lawrence and conclude that the Lugovoy Law is a miracle for the lawyers, both for Russians and international, because for the simple reason, beforehand, only English lawyers and probably Singaporean lawyers could sit at their places and enjoy anti-suit measure and laughing calmly saying and thinking, okay, if you go to somewhere else, I would issue the anti-suit injunction and prevent you from doing this. Now Russians could do the same and say, okay, if you would think of going somewhere, I go to the Russian court and get the anti-suit injunction. So I totally agree with Alex, and this is the who hits first, and it's a good strategy. To some extent, Lugovoy Law is a response to sanctions. I think, honestly, then if Russians would use this measure, would use this tool to prevent foreign companies from litigating and arbitrating somewhere else, except for exclusive Russian jurisdiction of Russian courts, then there should be some way of response to that. So which again create the cascade effect of creating the new law, court practice, case law, and so on, which is good for practitioners because you never stop and you develop, and cross-border disputes would go this way, and this is absolutely not the end of the story. To the practical points, just and the piece of advice, you never know, you're never stable, and you have to develop yourself and case law and practice and think very creatively. I think the law does allow us to create new forms of litigations and arbitrations.
Yeah.
Thank you so much.
Thank you very much, Dmitry. On that positive note that there's a lot of space for creativity, may I thank all the panelists for joining us today, for taking time out of their busy arbitration practice to share their expertise on this absolutely novel area. And even though we discussed the general COVID development first, I think we touched upon a very complex legal question in the second bit of the seminar. And more importantly, thank you, our viewers, for actually choosing to spend this hour with us. And we do appreciate it. So thank you very much and goodbye.
Thank you. Goodbye.
Thank you. Goodbye.
Bye. Thank you.